Hi, this is David Bliven, Bronx and Westchester divorce attorney with another episode of Lessons from the Divorce Wars. So this lesson comes in where I've had this experience with a number of clients in contested cases. So there's a big difference between uncontested cases and contested cases. So the uncontested case is generally predicated upon the parties reaching an agreement. So the key thing there is everything is by agreement. You cannot force the other side to do anything at all. So in other words, you file the case. The assumption is both parties are going to be motivated to reaching an agreement on custody, visitation, supports, asset distribution, etc. Most of the time parties exchange net worth statements and, some basic information, maybe some financial statements, etc. Sometimes you might ask for several months worth of statements, especially if one side or the other has a distrust as to whether somebody is hiding income or assets, or maybe got rid of some money out of bank accounts, etc. But generally speaking, everything is by agreement. Sometimes people get frustrated with that, and they say, well, gee, why isn't the other side being cooperative? What can you do, Dave, to force them? The answer is nothing. That's the whole point of a contested case. Now, the other flip side of that is the contested case, where everything is by court order. Generally speaking, the judge is going to set deadlines, and you have to follow them. You don't have a choice. So once they set deadlines for exchanges of discovery, you have to abide by them. It's not your choice to say, well, gee, I'm having trouble getting statements from my financial provider. The court's usually going to give you about 2-3 months to get those statements. So you better start moving really fast. Indeed, the preliminary conference rules say that within 10 days before the preliminary conference, you're supposed to exchange 3 years worth of tax returns, bank account statements, retirement account statements, investment account statements, and credit card statements. So if you already know a preliminary conference is coming, you're supposed to be getting those statements together already. So by the time you hit the preliminary conference, you really should have already gotten those statements over to your attorney. And like I said, if you can't download 3 years worth of statements, then you have to expeditiously contact your financial providers and get those statements in. Because you're going to have a real problem if the judge sets a deadline and 2-3 months down the road, you're still trying to get those statements together. It's not going to work. You're going to cause frustration for yourself, for your own attorney, for the judge that's trying to move his or her calendar. And you're going to face the possibility of sanctions, counsel fees to the other side, even in an extreme situation, preclusion of your ability to proceed on financial issues. So you got to take those deadlines really, really seriously. If you want answers to similar questions like this, check out my blog. You're going to find it at blivenlaw.net/blog. See you next time.